The SEC and Ripple have just filed a new joint motion that could finally bring the long-standing XRP case to an end. This is breaking news from the Southern District of New York, where the document was submitted yesterday, June 12th, to Judge Analisa Torres. This new motion is an updated version of a similar request that had previously been denied in May 2025 due to procedural flaws. The latest filing addresses those issues and is backed by what the parties describe as exceptional circumstances. Today, we'll break down the full contents of the motion, what it means for Ripple and XRP, and why this could signal the final chapter in a case that has lasted for years. Let's start with what the motion actually says. According to the filing, Ripple and the SEC have jointly requested the dissolution of the existing injunction in the case. They are also asking for the release of a $125 million civil penalty that Ripple had deposited in escrow. Out of that total, Ripple would pay $50 million to the SEC, and the remaining $75 million would be returned to Ripple. This joint request is significant. It not only seeks to resolve the penalty phase, but also reflects a major shift in regulatory tone from the SEC. Why now? The motion argues that the landscape has changed dramatically. The SEC is no longer under the leadership of Gary Gensler. Instead, the agency is now being led by Paul Atkins, under whom we've seen a more crypto-friendly policy emerge. This shift has already been reflected in the withdrawal of multiple cases the SEC had previously filed against other major crypto players like Binance, Coinbase, and more as of now. Ripple remains one of the few major projects still under legal pressure, though that may soon change. The motion points to a broader desire from both parties to avoid further litigation and to finally put an end to the legal battle that began in 2020. The court document highlights three key arguments: a mutual settlement agreement between Ripple and the SEC that a clear change in regulatory policy regarding digital assets, the need to preserve judicial resources and avoid prolonged litigation. Judge Torres had previously denied a similar motion due to lack of procedural compliance and insufficient justification. But this time, both the procedure and the context appear to have shifted. We asked Grok to analyze the motion, and it confirmed that the document includes a request for the dissolution of the injunction, the release of escrowed funds, and a civil penalty payment of $50 million. The other $75 million would go back to Ripple.s. What's next? For now, the case is still technically open. The motion has been filed, but it has not yet been approved by Judge Torres. Additionally, the U.S. Court of Appeals is still involved, and until the appeal is formally resolved, no final decision can be issued. This means that the legal process is still ongoing, but there is now a clear path toward closure. Once the appeal is concluded, Judge Torres will have the authority to accept the settlement and officially end the case. Meanwhile, there's another major update in the regulatory space. The U.S. Senate has officially scheduled a final vote on the Genius Act, legislation aimed at regulating stablecoins. The vote is set for Tuesday, June 17. This is a critical step for crypto legislation in the U.S., and it aligns closely with Ripple's latest strategic move, the launch of Ripple Dollar, a native stablecoin built on the XRP Ledger. With regulatory clarity around stablecoins expected soon, Ripple is positioning itself to take full advantage of the new legal framework. Let's recap what we've covered. Ripple and the SEC have filed a new joint motion to end the XRP case. The motion includes a request to dissolve the injunction and release escrowed funds. Ripple would pay a $50 million penalty and receive the remaining $75 million back. This follows a May 2025 denial, now corrected with proper procedure and new justification. The motion cites a mutual agreement, a friendlier SEC under new leadership, and a desire to avoid prolonged litigation. The Court of Appeals must still resolve the appeal before Judge Torres can finalize the case. Meanwhile, the Senate will vote June 17th on the Genius Act, a stablecoin regulatory bill. Ripple has already launched Ripple Dollar to align with upcoming U.S. regulation. In short, everything is pointing toward a resolution. The legal environment is changing. The SEC is pulling back. Congress is moving forward with new crypto legislation, and Ripple is preparing for life beyond the lawsuit. This may not be the very end just yet, but it's close. All that remains now is for the appeals process to finish and for Judge Torres to give her final ruling. Once that happens, the case could be closed permanently,